Good afternoon.
A very good afternoon.
Good afternoon, Your Lordship.
Do we have anybody from the Nairobi branch Law Society? Ms.
Yes,
Gashara?
Yona. Yes, I'm here. Can you hear me?
That's Ms. Gashara?
Yes. Can you hear me, Yona?
All right. Yes. Well, loud and clear.
Well, very well.
Okay.
So I can proceed?
Yes, you can.
So members, good afternoon. My name is Mudhoni Gashala. I am a council member at the LSK Nairobi branch. And this afternoon, we are privileged to have Justice Gatembu with us, the judge of the Court of Appeal. And today's topic is navigating the law and practice of the Court of Appeal, principles, procedures, and practical insights. I believe we will have a very interactive session and we are going to learn. So Justice Gatembu holds a Master's of Law degree from Boston University and a bachelor's degree from the University of Nairobi and a diploma in law from the Kenya School of Law. During his private legal practice, Justice Kairu worked as a legal assistant with HHM and also as an associate in Kimani Kairu and Company Advocate. He was a co-founder of the law firm of Kairu Makot, and he made a partner until the year 2009, when he moved to become a full-time arbitrator and mediator. Judge joined the judiciary in 2012 as a judge of the Court of Appeal. Prior to his appointment as a judge of the Court of Appeal, Justice Kairu lectured at the University of Nairobi since the year 1990. Further, he's a trained trainer in alternative dispute resolution by the Center for Africa Peace and Conflict Resolution, California State University, USA. He has trained and facilitated training workshops in Kenya, Ethiopia, and Tanzania. He is a fellow of the Chartered Institute of Arbitrators. In addition to his judicial functions, Justice Kairu served and continues to serve in various committees in the judiciary, including as chair of the Integrated Court Management System Committee. Therefore, ladies and gentlemen, this afternoon, please join me to welcome our speaker of today, Justice Gatembu Kairu, FCIArb. Karibu sana, Judge, with all these qualifications and your years of practice and also experience. I'm sure today we are going to learn a lot and we look forward. Karibu.
Thank you very much. You can hear me loud and clear?
Yes.
All right, very well. So thank you very much. Thank you very much, Ms. Gashara, for that introduction, and please convey also my gratitude to the chairman of the branch, Mr. Eric Kivuva, for having mobilized us to this training. So thank you very much. I also want to thank all your members, including I see senior counsels there, Mr. Mwenesi, I see Judith Gusero, among other senior counsel. Thank you very much for logging in. In adult education, we don't take much time, where our concentration spans are usually not very high. So I don't propose to speak for more than 25 minutes, and then we'll probably have a short session of Q&A if that will be necessary, or if you want to have that, and then we will close. So at the most, we take an hour at the very most, but for my speech, I think I will do about 25 minutes. So the topic is law practice at the Court of Appeal, principles, procedures, and practical insights. And the way I have structured my presentation is first to look at the legal framework and the jurisdiction of the court. And then from there, I'll move on and look at the practice and procedure and the prerequisites of approaching the Court of Appeal, including considerations of extension of time. Then I will speak specifically about applications for injunctions, applications for stay of execution, and applications for stay of proceedings. And then I will talk about some of the common challenges that we encounter. And I hope with that, I'll have at least covered a bit of the topic that you have asked me to address you on. I will leave out portions of preparation of memorandum of appeal and the principles upon which the court determines appeals. Perhaps if you will have me on another occasion when I can talk about that. But for now, that is what I propose to talk about. I will start with the question of the legal framework and the jurisdiction of the court. Now, the court is established under Article 164 of the Constitution, and its mandate is to hear appeals from the High Court and any other court or tribunals as may be prescribed by an Act of Parliament. The other courts, of course, include the courts of equal status, namely the Environment and Land Court and the Employment and Labor Relations Court. Prior to the coming into operation of the 2010 Constitution, we had the Appellate Jurisdiction Act, which continues to operate. And in its preamble, it had provided or provides that it is an act of Parliament to confer on the Court of Appeal jurisdiction to hear appeals from the High Court and for purposes incidental thereto. No doubt that provision in the Appellate Jurisdiction Act in Section 3 informed the language that we find in Article 164 of the Constitution, except that we had under the Constitution the provisions to encompass other courts and tribunals was extended. So Section 3 of the Appellate Jurisdiction Act provides that the Court of Appeal shall have jurisdiction to hear and determine appeals from the High Court and any other court or tribunal prescribed by an Act of Parliament in cases in which an appeal lies to the Court of Appeal. And I'm sure you'll have a chance to look at the entire Section 3 of the Appellate Jurisdiction Act as a reference point. Now, in one of the famous cases of the court, in the case of Equity Bank Limited versus West Link Ball Limited, Justice Gatembu stated that the Court of Appeal is a creature of Article 164 of the Constitution.
Okay, sawa.
Sorry. I can still be heard, I hope. Ms. Gashara?
Yes, Judge. Yes, Judge,
Right.
we can hear you.
All right, very good. Okay, thank you. Yes, so in Equity Bank Limited versus West Link Ball Limited, Justice Gatembu, I was saying, stated that the Court of Appeal is a creature of Article 164(1) of the Constitution, which establishes the court and can only exercise jurisdiction given to it under Article 164(3). He went on to say that the Court of Appeal has no supervisory role over the judicial process and can only exercise powers given to it by the Constitution, and that there is no right of appeal by implication or inference. And he went on to say that the source and extent of jurisdiction conferred to a court as stated by the Supreme Court in the case of Samuel Kamau Macharia versus Kenya Commercial Bank, the jurisdiction flows from either the Constitution or legislation, or both. And thus a court can only exercise jurisdiction as is conferred by the Constitution or other written law, and it cannot arrogate to itself jurisdiction exceeding that which is conferred by law. So that really is the constitutional underpinning, the statutory underpinning under which the Court of Appeal operates. And I think you are able to look at those decisions if you want to consider those further. Now, in terms of practice and procedure, Section 5 of the Appellate Jurisdiction Act empowers the Rules Committee to make rules for regulating the practice and procedure of the Court of Appeal. And in that respect, the Rules Committee came up with the Court of Appeal Rules 2022. There were obviously other rules before that, but the current operating ones are the 2022 rules, which practitioners or aspiring practitioners before the Court of Appeal need to master, much in the same way that you master the practice rules under the civil procedure rules and or the rules of procedure of the Court of Equal Status. My brother Justice Kiage at one point in the case of National Land Commission versus John Okira Musiga, when dealing with an application that was for extension of time, observed, and I want to quote what my brother Justice Kiage stated. He took a rather dim view of the manner in which the application in that case had been presented and the lack of reference to the rules that annoyed him, evidently annoyed him. He said this: "My surmise, which I am confident is quite correct, is that the respondents' counsel simply did not make any effort to peruse and acquaint themselves with the Court of Appeal Rules 2010, which is the first indispensable step of practice before us. It would seem they conceived in their mind the idea that they needed to seek extension of time and proceeded to draft an application for the same with scant regard to the rules of procedure and without care and attention demanded by the fact that the motion was for filing before this Court of Appeal, a forum of serious contemplation. That much is clear from the elementary blunders with which it is replete." And I think the judge emphasizes here the need of the point that I am making, that practitioners before the Court of Appeal must, of necessity, make sure that they acquaint themselves fully with our rules of procedure. Now, the other statute that may be worthwhile mentioning is the Court of Appeal Organization and Administration Act, which expounds on the mandate of the President of the Court of Appeal, as well as that of the presiding judges, and the manner in which the court is organized. And I will not spend any time on that. I'm sure you'll be able to look at it. It was an act of Parliament enacted pursuant to Article 164B of the Constitution. Moving on to the manner in which the Court of Appeal is approached, let me again cite from the words of Justice Gevenji, again in the Equity Bank case, where he said this: "The prerequisite for mounting an appeal to this court in civil cases and related matters is the lodging a notice of appeal within the prescribed time, followed by lodging in the court's registry within the prescribed time the memorandum of appeal, the record of appeal, prescribed fees, and security for costs." Now, of course, one needs to satisfy themselves before doing this that they have a right of appeal. They must be satisfied that the right of appeal exists. Rule 77(1) of the Court of Appeal rules provides that a person who desires to appeal to the court shall give notice in writing, which shall be lodged with the registrar of the court appealed from. Now, many young practitioners in our court do not pay attention to this requirement, in the sense that it is clear from that rule that the notice of appeal should be lodged with the court whose decision it is intended to challenge. It is not lodged with the Court of Appeal. Once lodged with the registrar of the lower court, it is the obligation of that registrar then to transmit it to the Court of Appeal. Now, that is the case, and I suppose I should point out at this point also that with specific reference to election petition appeals, the procedure is different, and I think one would have to acquaint themselves with those specific rules, because in that case, the notice of appeal is in fact lodged with the Court of Appeal as opposed to the High Court, and that is captured in the rules. So we have seen this, that a number perhaps of the young practitioners sometimes lodge the notice in the wrong registry, with the wrong registrar. The other lapse that we have frequently encountered is the omission, again by young practitioners, pardon me my saying so, some young practitioners, the omission or failure to hit the timelines prescribed for lodging the notice of appeal. And Rule 77(2) requires that it be lodged within 14 days after the date of the decision intended to be challenged. And then we have Rule 79(1), which requires service of that notice before or within 7 days after lodging. Now, I'm not quite sure why these provisions appear to pose challenges to some of our practitioners, because many then come to court with applications for extension of time under Rule 4 on account of lapses in complying with those rules and timelines. The other important step that should be taken immediately, the decision the subject of intended appeal is made or delivered, is to apply for a copy of the proceedings from that court. The request for a copy of the proceedings must be made within 30 days after the date of the decision that is the subject of intended appeal. And there is, of course, no reason why one needs to wait for those 30 days to lapse before doing so. And this requirement is critical because under Rule 84 of our rules, the time prescribed for filing the memorandum and record of appeal is 60 days after the date when the notice of appeal was lodged. However, there is, if you like, an automatic extension of that period under the proviso to Rule 84, by dint of which the time that is taken for the preparation and delivery of the proceedings is excluded. But there is a catch in that there has to be, the application for the proceedings has to be in writing and a copy must be served on the other side. And of course, that is what gives the basis for the registrar in the lower court to issue a certificate of delay. I would suggest that there is really no reason why all these steps should not or cannot be taken as a matter of course. As a matter of course, immediately a decision is delivered either by the High Court or the courts of equal status, irrespective of whether at that point one has instructions to do it. Because I think as a matter of caution, abundant caution, I think it is good practice, as we were taught by those who went before us, that to ensure that you preserve your position, and you do not then need to incur further expenses in seeking applications for extension of time, you can overcome that hurdle right away by taking those steps from the onset. If these rules are complied with, practitioners would easily save themselves and their clients and the court trouble, time, and costs of having to spend time on applications for extension of time. Quite apart from taking away the court's time in having to deal with the numerous applications for extension of time instead of having to deal with substantive appeals. I'll move on now and talk about applications for extension of time. Again, under Rule 4 of the Court of Appeal rules, the court is empowered to extend time limited by the rules or by any decision of the court or of a superior court. And by superior court, there is now a definition that includes all superior courts to include the Court of Appeal and the Supreme Court. But for this purpose, we are referring to the High Court, the ELC, or the ELRC. What is important to bear in mind in the exercise of this power is that it involves exercise of discretion on the part of the court. Justice Waki, in the case of Fakir Mohammed versus Joseph Mugambi, stated that the exercise of this court's discretion under Rule 4 is unfettered. There is no limit to the number of factors that the court would consider, so long as they are relevant. They include the period of delay, the reason for delay, chances of appeal succeeding if the application is granted, the degree of prejudice to the respondent if the application is granted, the effect of delay on public administration, the importance of compliance with time limits, the resources of the parties, and whether the matter raises issues of public importance. All these are relevant factors, but this is not a closed category of factors. The list is not exhaustive. The Supreme Court, in the same spirit, in the case of Nicholas Kipto Arap Koril, Salat versus IBC, pronounced that extension of time is not a right of a party, but an equitable remedy available to a deserving party at the discretion of the court. And the party that seeks extension of time has a burden to lay the basis to the satisfaction of the court. And each case must be determined on its own facts. Delay should be explained, and matters of other factors of consideration include public interest and whether the application is itself brought without undue delay. So again, those two cases, I think, provide a fairly good framework of the principles that the court uses in determining and in considering applications for extension of time. I'll move on to the more notorious applications under Rule 5(2)(b). These are applications for injunctions, applications for stay of execution, and applications for stay of proceedings. As you know, the filing of a notice of appeal or the institution of an appeal does not by itself automatically suspend the implementation or execution of the decision that is intended to be challenged. So under Rule 5(2)(b) of the Court of Appeal rules, the court is empowered in any civil proceedings where a notice of appeal has been lodged in accordance with Rule 77 to order a stay of execution or to grant an injunction or to stay further proceedings in the lower court until the appeal is determined. Again, Justice Gedenji, in that same famous case of Equity Bank, described this rule, Rule 5(2)(b), as a procedural innovation designed to empower the court to entertain an interlocutory application for preservation of the subject matter of the appeal in order to ensure that just and effective determination of appeals. So that case is quite important, I think, in the practice of our court. It is also important to bear in mind that in dealing with applications under Rule 52B, the court is exercising, as we have said, judicial discretion. And the fact that a similar application may have been made before the High Court or before the ELRC or before the ELRC, and that the application had been declined there, does not divest the court of the power to exercise this discretion. So in dealing with an application under 52B, the court is said to be exercising original jurisdiction and is exercising original independent discretion in doing so. The principles under which applications under this rule are considered are, I think, are fairly well known. There are very many judicial decisions from our court that pronounce this. I can only refer to Stanley Kang'ethe Kinyanjui versus Tony Ketar, which is frequently quoted before us, because it fairly extensively sets out the parameters for considering these applications. The two main considerations is whether the intended appeal is arguable, and the second one is whether, if the stay is not granted, the appeal, if successful, will be rendered moot or academic or nugatory. So the case in Stanley Kang'ethe, I think, is important for especially the young practitioners who come before us to look at, because it fairly elaborately captures and summarizes the principles based on precedents of the court. The question of arguable appeal is fairly easy to surmount because the threshold is fairly low. And oftentimes we see advocates appearing before us, struggling with this issue, trying to oppose an application on the basis that the appeal is not arguable. And even when they listen to themselves, I would dare say that they appreciate. But I suppose they have instructions to oppose, and they must do so at every cost. So the threshold for arguability is fairly low. Because, as you know, it need not be an argument that will necessarily succeed on the appeal. I think the only requirement is that it is established that the intended appeal is not frivolous. The second limb is obviously more problematic and more difficult to surmount, and I think that is where more energy should be channeled. Let me talk specifically now about the issue of staying proceedings, because under Rule 52B, as we have mentioned, the court is also empowered to halt or to suspend further proceedings before the lower court pending the determination of the appeal. In the case of Lalita Devi Lalchand Galot versus Mohan Galot, this court endorsed, the Court of Appeal endorsed the view in Halsbury's, expressed by the editors in Halsbury's Laws of England, that the stay of proceedings is a serious and grave fundamental interruption in the right that a party has to conduct his litigation towards the trial on the basis of the substantive merits of the case. And therefore, the court's general practice is that a stay of proceedings should not be imposed unless the proceedings, beyond all reasonable doubt, ought not to be allowed to continue. And I think most of the decisions of our court in respect to applications for stay of proceedings, I think, have been faithful to this principle. I think more often than not, the applications for stay of proceedings are declined so that the the High Court or the ELRC or the ELC is able to proceed and finalize its business, and then whoever is aggrieved there can then move the Court of Appeal at that stage without having to clog the system in the court below. Again, in the same vein, Justice Rengera is famously quoted with the same principles in the case of Global Tours and Travels Limited to the same effect, that it is the rare case where an order for stay is given. Now, some of the common challenges we see in relation to all these applications is some of the following. One, we see counsel sometimes presenting an omnibus application that combines applications or prayers for reliefs under Rule 52B with prayers for extension of time under Rule 4. Quite apart from the fact that this is untidy, and I say so because the application for extension of time under Rule 4 is required to be heard by a single judge, whilst the 52B application is for the full court. So invariably, when the prayers are combined, the court is then constrained sometimes to refer the matter to a single judge. And of course, that costs the litigants time and expense in having to wait for the single judge to deal with that application before then pursuing the other reliefs that should be properly pursued before the full court. The other challenge I think that I should mention that we see in these applications is in crafting of the prayers in the application. There are many instances where we have seen applications in which orders are sought for staying of what are generally referred to as negative orders of the lower court. For example, where a suit before the High Court is dismissed or before the ELRC or the ELC is dismissed, without requiring either party to do anything, the order of dismissal is not one that is then capable of being stayed. If the intention, as it must be, is to safeguard the property that was the subject of such a suit, the appropriate relief to seek is to seek an order for injunction under Rule 52B, not an order for stay of execution. In the case of Mwandi and two others versus Mukami, this was clearly stated where the Court of Appeal stated that it is quite clear that the application in the High Court was dismissed. Let me quote the passage in its entirety. The court said, from the record, it is quite clear that the application in the High Court was dismissed. It is this order of dismissal that the applicants intend to appeal against. As already stated, the jurisprudence of this court on applications for stay of execution pending appeal is now settled. The position taken by this court in respect of such applications for stay of execution of negative orders is that they cannot be stayed. In other words, for an order of stay of execution to lie, the order or decree sought to be stayed must be positive in nature. And then in Western College of Arts and Applied Sciences versus Oranga, again, the same message is set there. And also you'll see the same message in the case of Cooperative Bank of Kenya Limited versus Banking Insurance, where, and I think I will quote this one, where the court said, an order for stay of execution pending appeal is ordinarily an interim order which seeks to delay the performance of positive obligations that are set out in a decree as a result of a judgment. The delay of performance presupposes the existence of a situation to stay called a positive order, either an order that has not been complied with or has partly been complied with. And that is really the position. So where we have seen many applications having to be withdrawn simply because the prayers that have been sought in the application have not properly been articulated, and sometimes they are seeking to. So this is something to pay attention to, I think, especially for the young practitioners, so that you are not sent back to the drawing board to start afresh. And this really is not a technical. There are those who would argue that this is a technicality, but it certainly is not in our view. Finally, let me just say something about certificates of urgency. Most of the applications that come to court are initiated through a certificate of urgency. And this is quite understandable because the backlog in our courts is serious. Right now, the Court of Appeal in Nairobi is dealing with appeals from 2019, 2020. And the consequence is that even when applications are certified urgent, they really don't receive urgent attention by the court. And I think this is a practical problem that the court has very little control over. But having said that, many a time we have seen certificates of urgency and affidavits that really do not bring out the urgency in the situation that, so for instance, you might find a certificate of urgency that simply says the judgment of the High Court was delivered on this date, the orders that were given are likely to be executed, and we pray that this be certified, without really giving details as to what is the threat, what is the urgency. So the point I want to make here is that there is need to pay particular attention to the requirements of Rule 49 of the Court of Appeal rules, so that you avoid a situation where a matter that is otherwise deserving to be prioritized is not prioritized simply because there is dearth of information in the affidavit and in the application in support of the urgency. And finally, and very lastly, I think I've spoken for more than the 20 minutes that I had set out to do. Let me just talk about a few common challenges that we have seen. And I would say that these are more in the exception than as the general rule. One, we have had counsel coming before us who evidently were instructed on the eve of the hearing of the application. And it becomes quite clear when the counsel simply says, I rely on the written submissions, but when questions are posed to that counsel, they are not able to provide the clarification that may be required. So that goes hand in hand with the complaint that we have sometimes of lack of adequate preparation. The other one, and I have already alluded to this, is the failure to comply with the timelines that are set out in the rules, which then leads us to getting bogged down with applications for extension of time. There is also the timelines that are given for filing of submissions, and the failure again to hit those ones. Oftentimes we find that submissions are being filed on the morning when we seized of the matter and will not have had a chance to review that material beforehand. There is then also the question of connectivity, sometimes real, sometimes we suspect feigned, especially in this day where I think we are all doing work virtually, and the opportunity to multitask and have a number of court cases going. You might find a counsel is actually before another court, but they are not coming forthright with it. And they say they're having connectivity issues to ensure that they are then getting to deal with all the matters. And I think there can be better organization where one is able to get assistance from other counsel on that matter. Then there is the sometimes very disruptive backgrounds in these virtual platforms. When counsel is appearing and there is a lot of activity behind the counsel, that becomes quite disruptive. There is also decorum, which I think we all, agree must be maintained. Sometimes we get counsel stopping by the roadside in their vehicles, and they want to address us. Usually the typical thing with that practice is that they tell us they are relying on their submissions, and then they get on with their other farming or other business that they want to undertake. And finally, we have had limited issues of dress code, people not being properly dressed. So let me stop there, Ms. Gashara, and say that I would have liked to deal with substantive appeals and the principles that the court uses in determining those appeals, to the extent that they should inform the skill of crafting memoranda of appearance and so on and submissions. But I hope you can invite me again on another occasion to talk about that. So thank you very much. I will stop there. Thank you.
Thank you very much, Judge, for that very wealthy presentation. So we have questions from members. So I would suggest you can respond to a question one by one. So I will begin with the first question from Irene. The same is regarding the issue
Sorry, Ms. Gashara. Perhaps you can give me 3 questions at a time, and I deal with that, and then we take another batch. Did you get me?
No. I didn't get you.
I am suggesting that maybe you take 3 or 4 questions at a time, and then we take another batch. Yes.
Okay, we can take 3. Very well. I stand guided, Judge. So the first question is from Irene regarding the issue of stay in respect to a negative order. Is it cast on stone that stay orders does not apply on negative order, and the Court of Appeal cannot exercise discretion to protect the interests of the parties and to preserve substratum of the appeal? Can the court exercise discretion even if the trial court's orders are of a negative order? Then she proceeded to ask, I think, a follow-up question on the same issue of negative orders. Demystify the issue of negative orders in respect to Rule 5.2b of the Court of Appeal Rules 2022. Then the third question from another Irene. When seeking application to extend time, is it advisable to file the appeal and then seek to be deemed proper, or file an application and wait for the determination? Then, Judge, you can proceed with those 3 questions.
All right. Thank you for those questions. Now, on the negative order, I think the jurisprudence has been fairly clear and consistent, because an order for stay is certainly different from an injunction. And I think as long as counsel are careful in crafting the relief that they seek, and we are always told that pleadings bind us in as much as they bind the parties. If counsel are careful in the crafting of the relief that they seek, then there shouldn't be a problem with that. And this is where I mentioned from the outset that we don't perceive this as technical justice. I think it is substantive to the extent that the underlying principle is that parties and the court are bound by the pleadings. Now, in terms of the question relating to the extension of time, I think we are not, I think there are different schools of thought in our court in this regard. Firstly, the Supreme Court rules, I think, have been interpreted by the Supreme Court specifically to say that you cannot deem a pleading that is filed outside the time frames as properly filed. But I think in our court we have invariably cured by deeming as done that ought to have been done. But I think to be on the safe side, so that you do not encounter, as I say, there appears to be two schools of thought on this, so that you do not encounter difficulties, I think the best thing to do is to make the application perhaps for extension of time and then seek directions in terms of the time frame within which to file. I think those were the questions, Ms. Gashara.
Yes, Judge. The next set, we have Wilson. He is asking, kindly address the issue of an expanded bench and how to go about it. Chege Kamau asks, and on review application of a single judge order in the e-filing platform, there is no provision for filing of a reference as required by the court. So how does a litigant navigate the same? If you can't answer it, I don't know whether the DL is with us. They can also respond on that, because I feel it's also a bit administrative. Then we have that question. The Court of Appeal is viewed by most as a procedural focused court. How does the court balance this with its substantive role, that is by laws of BAG? Judge, you can proceed.
Thank you very much. Let me just reach out for. Okay. On the question of the expanded bench, Rule 29, I think it is, that's what I was reaching out to confirm, that is the one that deals with that. It says that a party, Rule 29 of our rule says that a party may apply informally, but in writing to the president with notice to the other parties for an appeal or application to be heard and determined by an expanded bench consisting of 5 or more judges of an even number. So it takes the form of a letter addressed to the president. But the circumstances under which the president does this is fairly limited. If, for instance, you are able to establish that there is no uniformity or consistency in the decisions on a particular issue by the court, then that is the way to go. So the president will then say, if you draw the attention of the court to the conflicting decisions of the court, and that is a route that is then open to try and get an expanded bench to deal with that issue. On the question of review and the absence of facility within the CTS for that, I think that is a matter I can take up and find out what needs to be done. But I know presently, and I'm sure there are counsel here who can also speak to this, presently the reference is by way of a letter once the decision of the single judge is delivered. But I'm not quite sure how that is then done on the system. And then the third one was the question of procedure of a substance. I think historically that was the case before the 2010 Constitution. But after that, I think the court has embraced Article 159. indeed, the statute that governs us, the Organization and Administration Act, is very clear that the duty of the court is to do substantive justice, just as Article 159 prescribes or commands. And I think we have, to a large extent, endeavored to live with this. So it's unfortunate that if the perception is that we have slid back to the pre-2010 position. So, but I think my view on this is somewhat different. Thank you.
Yeah, thank you, Judge. The next set of questions, Chege asks, in the computation of time, where a party who has satisfied the provisions of Rule 84, is the appeal still intact if the proceedings are unreasonably delayed, say after 36 months? Then he also asks, please clarify on application under Rule 5.2 for money decrees and the position of the court in the use of bank guarantees as security for stay. Then the third question from Abigail, kindly expound on the issue of granting an interim order for stay under Rule 5.2b, especially in delicate cases like eviction. Can it be granted ex parte?
Thank you. Thanks again for those questions. Now, under the provisions of Rule 84, as long as there is a valid certificate of delay, and the delay has been occasioned by the court that is preparing the proceedings, yes, I think it is still acceptable, and the extension of time is still recognized. So my answer to that is yes. But we have also had cases where certificates of delays have been challenged on the basis that they have been obtained under unclear circumstances, but I suppose that is a different matter. In as far as the money decrees are concerned and the matter of stay, there is no hard and fast rule over this. We have had situations where the amount involved is so large that the court has taken cognizance of that fact. And so whereas it might have been the principle before that ordinarily there would be no stay for money decrees, I don't think that is the current position. So yes, irrespective of whether the decree is a money decree or not, I think where circumstances warrant, the orders under 5.2b are allowable. In terms of whether an ex parte order is permissible, unfortunately, our rules do not permit this. And I think this is a matter that has been the subject of some fairly serious debate on the question of law reform, whether the Court of Appeal rules should be amended to permit for ex parte orders. There are those members of our court who feel that, yes, it should be permissible because the courts below have the mandate to do so, and we should be able to do so. There are those of us, and I belong to this latter category, who believe that as an appellate court, we should not be granting ex parte orders without having heard both sides. And especially in the current context where things are done fairly speedy, with the use of connectivity and internet, there can hardly be any justification for us to go that route. But that is my personal view. The others who hold a different view. Thank you.
Thank you, Judge. The next set of questions.
I don't know whether it is my connection that has gone or yours.
The Court of Appeal need evidence of ongoing threatened execution. See in an application for stay. Judge, can you hear me?
I think I don't know whether it's my connection that froze or it, can you hear me?
That you can hear you. But I think
okay.
her connection has a.
All right. Oh, thank you. So, Ms. Gashara, I think your connection is the one that has a challenge.
Can you hear me now, Judge?
Yeah. Yes, that's better. That's better.
Okay. Thank you. Sorry about that. So, Wilson asked, does the Court of Appeal need evidence of ongoing threatened execution, such as a decree or warrant, to see the agency in an application for stay, or is it sufficient to show that stay of execution was not granted at the Superior Court, or that stay period is almost lapsing? The next question is from Asharia. Is it proper to file an application using an existing appeal case number, or should the application be filed as a new application with a new application case number? Then the third question from Abigail is kindly address the process with respect to appeals arising from succession causes. We can have those ones, Judge.
All right. Thank you. Thank you. The answer to Wilson's question is that I think it is in the interest of your client to present as much material as you possibly can have that demonstrates the urgency. So for instance, in the example that you have given, the fact that there are warrants and so on, I think make the point more clearly that there is imminent danger which calls for intervention. So I would say in as far as those requirements are concerned, to demonstrate urgency, the more persuasive and the more convincing material that you might have, use that. On the question, I believe, by Masharia, whether to file an application within the existing appeal or to file an entirely new number, I would say that the preferred is that if there is an existing appeal, file it within the existing appeal. Because I think that way, the court then gets to appreciate the matter in the context of that appeal. So I would say that go with the existing appeal, file the application within it. For Abigail, on succession matters, I think there is also the question here whether there is an automatic right of appeal in succession matters or whether you need leave. Again, this is an issue I think that has split the court, but the predominant view now seems to be that leave is required. I think the more recent decisions on this is that leave in succession matters is required. But as I say, there are those cases which take a different view from our court. Maybe this is a matter that needs to be resolved. And perhaps, as one of the council raised, an expanded bench might be the way to look at this, or escalate the question to the Supreme Court.
Thank you, Judge.
So maybe we take, I see we are approaching, how much time were we giving for this?
It's okay. I think we have until 4.
Right.
And members, I think, are very happy with this session. We have very many questions, and that is a very good thing.
Very well.
So, yes. So, Judge asked, sorry, Judge. So, Judge asked that, can you just mention what to look for in drafting substantive appeal, especially on grounds? Then Dennis asks, how does the court reconcile itself with Article 159(2)(d) with a party who misstepped a procedural requirement? Then the third question, I don't know who Holmes PC is. Why does the Court of Appeal virtual court links? I think this is more of a comment and a clarification. Why does the Court of Appeal virtual court link are they not available to the public like other courts? Young lawyers can benefit from attending the sessions for learning purposes.
All right. Thank you. The first question, I didn't quite get who asked the first question about the drafting of memorandum of appeal. And I had indicated that if you can have me at a subsequent session, I'll be happy to deal with this a little in more detail. But I think what I think one needs to keep in mind when drafting a memorandum of appeal is to know the nature of the decision that is being challenged. Is the decision being challenged a decision made in exercise of discretion? If it is a decision that is made in exercise of discretion, what are the principles on which the Court of Appeal can interfere? So one needs to have those principles in mind when seeking to attack the manner in which the High Court or the ELC or the ELRC exercise that discretion. So I think that is a critical point. Again, if it is a first appeal or a second appeal, if it is a first appeal, we have the mandate under Rule 33, I think it is, to be able to evaluate the evidence. Again, that should inform the manner in which you critique the judgment of the lower court, and that should inform you how to craft the memorandum of appeal. Now, I didn't quite get the question on Article 159, and I suspect this links with the earlier one where I think one of the members indicated that the Court of Appeal is more procedural than substantive. I didn't quite get that one. But I think I had suggested that in my own personal opinion, I think we have leaned more now on substance than in procedure, and perhaps we can do better in that respect. And then the question of the virtual courts and availability to the public, I think I was not aware of this, and thank you for drawing this to my attention. I will inquire and find out why this is so. I thought the links are generally shared with the advocates and also the parties, so that if the advocates then wish to, for want of a better word, sambaza that link to their clients or whoever else might be interested, I don't know. I'll have to find this out. And perhaps
Judge, just a minute. I think the way I understood it, this Dr. Ginariri, is,
sorry?
This Dr. Ginariri, the way I understood that question, Judge,
yes,
is that, the links we have in other courts are permanent links where anybody, even from the US, can just log into High Court and they click a link to a court.
All right.
In the Court of Appeal, that's not the position.
Okay.
The position is that you have to send to the advocates and then the parties, as the case may be. Judge.
I will find out the rationale of that. Thank you very much, Daktari. I will find out the rationale for that. Ms. Gashara, I think I have answered.
Yes, Judge.
Yes.
Yes, Judge, thank you. The next set of questions, Anthony asked, is 10th lining still necessary? Or is it now 10th lining still necessary, or is it now redundant in the era of digital documents and automated page numbers? Then the other question, where the High Court has issued a dismissal order, but with a positive connotation, like let's say dismissal of an application, then asserts what a status quo should be, can that order be challenged under Rule 5(2)(b)? Then Sadia asked, does Rule 5(2)(b) equally apply to criminal trials, or is it strictly limited to civil cases? Which rule would expressly apply for criminal trials, please?
All right, thank you very much. On the first one, the lining and the pagination and so on, I think this makes the reference when one is then making reference to the record. even in the context of the virtual scenario, it is still very helpful. Because when you refer the court, say, to page 10, and you want to draw the court's attention to a specific paragraph or sentence, I think it makes it much easier to follow that numbering on the margin. So that is still, I think, in my view, relevant. On the question of dismissal order with a positive connotation, I think, let me make it myself very clear. I did not say that under Rule 5.2b an application cannot be made when there has been a dismissal. What I said is that you need to craft your application to seek the appropriate relief. If, for instance, you want something stopped, you ask for an injunction. There is somebody, Warogoro, who's decided to entertain us. All right. So I was saying that I did not say that that a ruling or a judgment that results in a negative order is outside the scope of applications under 5.2b. You can still make an application under 5.2b, but craft the relief that you seek that is appropriate to the circumstances that you have, so that if it is an injunction that is you require, then you ask for that. Now, in terms of whether 5.2b applies to criminal, what applies to criminal is not 5.2b, it is 5.1. Rule 5.1 simply says that no sentence of death shall be carried out until the period for giving notice of appeal has expired, or where a notice of appeal has been given until the appeal has been determined. And then 5.2a then says, subject to sub-rule 1, the institution of an appeal shall not operate to suspend any sentence or to stay execution, but the court may, in criminal proceedings, that is 5.2a, in any criminal proceedings where a notice of appeal has been given in accordance with Rule 61, order that the appellant be released on bail, or that the execution of any warrant of distress be suspended pending determination. So I think that is where your answer lies with that.
Sorry, Judge. I want to ask the question.
Yes.
It was not limited to bail. In other circumstances where it's not limited to bail,
yes,
where you need a stay and it's not limited to bail. Because
yes,
Rule 5.2a, it's limited to bail. Yes, sorry, thanks.
5.2a, I think, says, subject to sub-rule 1, the institution of an appeal shall not operate to suspend by the court in any criminal proceedings where a notice of appeal has been given, order the appellant to be released, or that the execution of any warrant of distress be suspended. But I would have to look at, I haven't looked at the jurisprudence on this, but my initial reaction to it is that it is available. But I would stand to be corrected. Ms. Gashara?
Yes, Judge.
Are we done?
No. We have a few more.
All right.
Just be patient with us. We are very eager. Yes.
Okay, very well.
So we have my senior Jane Odia asked, where the High Court issues a stay for its decision, then an application for lifting its stay is allowed by it. Can one challenge that lifting of stay by the High Court under any Court of Appeal rules? Then Claire Mwangi asks, is there jurisprudence on application for review of order under 5.2b, ruling and order? Then Edgar asks, with regards to Rule 85, what is the effect of not having filed an appeal within the timeline, even though there was delay with proceedings? And does this affect an application for stay that has not been had within 60 days?
Okay, I'm not sure I got the last question. The first question was where a stay has been granted by the High Court and it has subsequently been lifted, can the Court of Appeal still grant a stay?
So the question is where the High Court issues a stay for its decision, then an application for lifting its stay is allowed by it.
Yes.
Can one challenge that lifting of stay by the High Court under the Court of Appeal rules?
I think you need to look at the provisions on whether that is an order that is appealable under the provisions of the civil procedure rules. I think you'd have to look at that. I am not sure myself. But as I said, the jurisdiction under 5.2b is original. It is not an appellate jurisdiction. It is original jurisdiction where the court exercises its discretion as an original jurisdiction, as an original discretion as well. So it is not sitting on appeal from the decision of the High Court that either granted or refused to grant stay. So I don't know whether that is helpful at all. I'm not sure I have answered that question. The question by Claire about application for review of a decision, what was specifically what? Could you repeat?
Specifically review of a ruling or order under Rule 5.2b.
Yes, I think there is a case of, is it Champole? Somebody, yes, there is. There is a mandate to review. I think we have the case of Manchester and Standard Bank, and we also have the case of Champole, where I think a decision that we had made as 3 judges was then reviewed by a panel of 5 and reversed. So I think the answer to that is yes, there are cases for that. And I think if you go on to Kenya law, you should be able to access them. What was Edgar's question about Rule 85?
So with regards to Rule 85,
yes.
What is the effect of not having filed an appeal within the timeline, even though there was delay with proceedings? And does this affect, and then he continues to ask, and does this affect an application for stay that has not been had within the 60 days?
I'm not sure I get the second part of that question, but Rule 85 is the deeming provision. And I think the jurisprudence about Rule 85 is that it is a tool that the court has for if you like, cleaning out. So it is more in the category of the jurisdiction that the High Court has for dismissing cases for want of prosecution. I think this is the closest we have to that. I'm not sure I got the second part of it. I think fatigue is also setting in. But what was the second part of this?
Does this affect an application for stay that has not been had within the 60 days?
I don't know whether there is a requirement to hear applications within 60 days. I'm not sure I'm following this. Maybe Edgar can clarify.
My lord, good afternoon.
Good afternoon, Edgar.
My question was with regard to that Rule 85 and specifically whereby if I fail to lodge my appeal or if I have done a notice of appeal and the same has not proceeded within 60 days, you will find also there is an instance whereby maybe my application...
Meaning if you have lodged a notice of appeal and you have not filed a record of appeal.
Yes, my lord.
Okay.
So what happens in a situation whereby now even my application for stay has not been had within those 60 days? What will be the effect of that?
You know, without a notice of appeal, there's nothing that empowers the court to do anything. So if the notice of appeal is deemed as withdrawn and on it was hinged an application for stay, then it has no footing. I think that would be my response to that. I hope that answers you, Edgar.
Not really, my lord. I just wanted to inquire. You will find a situation whereby the court will certify a matter and issue
Yes.
directions. But the same is now with regards to an application. But mind you, I have not been able to file my record of appeal. So what would be the effect of this application, which is now not had within the 60 days?
Where are you getting the 60 days within which the application must be had, Edgar? Maybe I
And not really that it ought to be had within 60 days, but I was just trying to understand that particular effect of Rule 85 in a situation whereby even my application is not had within those 60 days.
As long as the notice of appeal is still in place and the application for stay is also in place, I don't think there is a problem. I think you just wait to get a hearing date for that application. But if for any reason the notice of appeal is either struck out or deemed as withdrawn, and there is also a pending application for stay, I think then that application for stay has no basis at all. It has no footing.
Much guided, my lord.
Yep. All right.
Thank you, Judge. George asked the challenge we face with waiting for application to extend time is that it will be hard after 3 years. If you file after the ruling, it may take another 3 years. It will mean the appeal, which was late by 1 day, is hard after 6 years. Then there's an observation, also maybe Judge, you can note this, that the CTS also does not have an option for a letter unless sent by email. Then Bichire says, in light of the judiciary's digital transformation agenda backlog, would you recommend the Court of Appeal can effectively adopt the Mahakama Popote concept to facilitate virtual hearings in any station to uphold access to justice? Then the last question on this set, we still have just a few more. Can we then say that the issue of filing for extension of time before filing an appeal and filing the appeal before seeking extension is ripe for an expanded bench since we have different positions from the Court of Appeal?
Thank you. Let me start with the last one by simply saying that this is a matter for the president to determine, and I would rather not express a view one way or the other about it. If you're able to make the case before the president, please do so and see whether the president will be persuaded. So I think that I can leave at that. Mishire, on the Mahakama Popote, I think, yes, to a large extent, we are somewhat already doing this in the sense that when the judges in the outer stations do not have a quorum for whatever reason, either one judge is sick or is indisposed, we still step in and deal from wherever we are. I have noted the point about the CTS lacking an option for letters, and I will escalate that. The first question on delays, I think I mentioned that we have a serious problem of backlog, and I'm not quite sure how we address this. We are trying now to invoke Rule 108 of our Court of Appeal rules with respect to mediation to see whether we can channel some of the cases that we have to alternative dispute resolutions or to AJS where appropriate. And I want to take this opportunity to appeal to all of you to embrace this and to give it a try. Because even, as you know, we are expecting to get another 15 judges. I saw that interviews will start in January. But even with the 15 more judges, and bearing in mind that we sit as 3, the benches are still fairly few relative to the volume of work that we have. Currently, I think as the last check, we had over 5,000 pending appeals and almost a similar number of pending applications. So that even if you bring 15 judges, we still have to find other ways in which we will be able to overcome these delays. And I think I can leave that one there. So yes, we have serious challenges, even with applications for extension, even with applications that are certified urgent. We are not able to deal with them in real time as we should and as we aspire to do. Ms. Gashara?
Thank you, Judge. Yes, in judicial review appeals, when an order of stay of execution is sought, will the court demand for security for costs?
Typically, okay, all right. Well, I had begun to answer that and to say that I think the discretion we have under Rule 5.2b, including it includes on such terms as the court may consider. So ordinarily, I think it is the rare case that when we grant these stay orders that we ask for security for cost. I think the considerations under the civil procedure rules for stay are very different, and I think you might want to familiarize yourself with this distinction. The provisions on stay in the High Court, for instance, under the civil procedure rules are different from the considerations for stay in the Court of Appeal. So it is not usual that we ask for this. Sometimes I think when security is offered, it could be a bank guarantee or a bond and that sort of thing, or depositing money in joint accounts. I think those are the sorts of things that we see.
Yeah.
Next.
Thank you, Judge. The other question is, what is the best approach when a party files an application under Rule 5.2b, yet they fail to comply with the provisions requiring service of the notice of appeal and later bespeaking proceedings? At what stage can you challenge the propriety of the intended appeal? Then, under what circumstances can the Court of Appeal reevaluate evidence and matters of fact while sitting as the second appellate court? That is by Kevin. And the third question is, in a scenario where the ELC court gives a negative order, yet there is a succession proceeding at the magistrate court that could distribute funds that is subject of the ELC suit, can an application for order of injunction be done at the Court of Appeal to stay proceedings at the magistrate court in order to preserve the suit property? That's a big, it's a long question, Ioana. Could I repeat the same, or you got it, Judge?
I'll probably even, I hope that is not a matter that is currently before us, so I think I would rather not respond to that question. The question of evaluation of evidence, I think it is Kevin who has asked that. Our rule 33.
Colleagues, please, let's mute ourselves kindly. Thank you.
Yes. I'm trying to locate the rule that gives us the power. Is Rule 31. Rule 31, which says that we have the power to reappraise evidence and draw inferences. But that is on a first appeal. So on a second appeal, I think the question that translates to one of law would be whether the court that the first appellate court discharged its function in that respect. So that is the way I think that would become a question of law for which then the court can look at. On the first question, I think the answer would be in Rule 86 that has provision for making application to strike out. If I understood the question correctly, then the avenue is to apply to strike out under Rule 86.
Thank
Ms.
you, Judge.
Gashara?
Yes, Judge. We have a question. So Council Japheth is requesting that you advise advocates who encounter pressure to file appeals that may not have merit, particularly in balancing the advocate's duty to client and to the court. And then Waruguru
Sorry,
asked.
could you repeat that, please, Gashara?
Yes. So Japheth is requesting that you advise advocates who encounter pressure. I think this is based on your long practice years and your experience on both the bench and the bar, who encounter pressure to file appeals that may not have merit, particularly in balancing, may not have merit, so particularly in balancing the advocate's duty to the client and to the court. And then Waruguru asked, she says this is not, it's probably not related to the practice at the Court of Appeal, but what is the position of the Court of Appeal in regards to a matter where a matter is dismissed for want of prosecution? And would the principle of res judicata apply when a party files the case again, viewing as it was not determined on merit? Then the third question, I think after this we will know, you'll permit us members to go to our last set after this. This is our second last set. So what is the position of the court for an application to set aside orders to judgment overtaken by events? For example, where sale has already been effected, will the court accept to set aside when a third party has already been involved?
All right, thank you. I don't know whether Mr. Mwenesi is still with us.
He is.
Mr. Mwenesi?
Yes, ma'am.
Can I kindly request you to answer this first question, where you get pressure to file a hopeless appeal knowing it has no legs?
Let me, if I could get the question properly, let me see whether I have it on the.
Yeah, the question, if I understood the question correctly from Mr. Japheth,
I think, yes.
was that
What is the advice to advocates who encounter pressure to file appeals that may be unmeritorious?
Yes.
I think it's a question of what is the ethical position? You are an advisor to your client. You have to advise them on merits or demerits of their appeals and their case. And as Japheth says, there is also the duty to the client, and that perhaps this is where that the customer comes first, the client needs come first. Do you go ahead and incur the costs of something that is really unmeritorious? And that's where I think the advocate's opinion, professional opinion, has to be given to the client, and preferably given in writing, setting out the reasons why, and then get something back in writing to say, I'm insisting you go ahead, because there is also the professional challenge that could come up that you were negligent and the appeal was dismissed when the client knew that it was going to succeed. We have experienced these many times, but it really depends on one's own ethical standing and take in the matter.
Thank you. Thank you very much, Mr. Mwenesi.
And
Mr.
thank you for the honor.
Thank you very much. Mr. Japheth, I think there you have it. Then there was Waruguru. What was the question about a matter is dismissed for want of prosecution? Is it res judicata? Is Judith still with us? Guserwa? I think, Waruguru, I can only refer you to the cases that, that discuss the principles of res judicata, the conditions that need to be met, and I think you need to look at those. So let me not give you what might be tantamount to legal advice in that respect. So please look at those decisions. The third question was the question of whether a matter overtaken by events is moot. Gashara, please refresh my memory on this.
On the question?
There was a question, the last question about a matter being overtaken by events.
Yes, Your Honor. What is the position of the court for an application to set aside orders where judgment has been overtaken by events? For example, where a sale has already been effected, will the court accept to set aside when a third party has already been involved?
I think if I understand the question correctly, we encourage where say, for instance, there is a 5(2)B application before us that, say, for instance, was trying to stop the exercise of a statutory power of sale, say, by a bank, and the property has already been sold and it's moved on. I think we encourage the parties to acknowledge that that is the position and perhaps seek redress elsewhere. Or in other ways. So I think we try on the whole to avoid engaging in strictly academic exercises where really we will not make a difference to the positions.
Yes,
maybe the last set of questions. Yeah.
Yes, and I have a request. My apologies. Maybe if we could just maybe extend 15 minutes or maybe less. I'm seeing 7 questions, and Judge, I am seeking to be elected, and I don't want members to hold that against me. Please allow us to just answer their questions.
How about this as a compromise, Gashara? If the branch has an interest in having another session, we can certainly have another session and combine the remainder of the questions with the remaining aspect of appeals, preparation of memoranda of appeal, the principles that guide us in making decisions. And maybe we can have that session, unless I have bored your members to kingdom come.
That could also be an option, Judge, but I think maybe that could be in the next term.
Yes.
Is 15 minutes okay with you, or we will be stretching?
I think let's do 5. Let's do 5.
Okay.
Yeah.
Then let me just read the question. So there's a question. I think this question had been asked, but probably I think maybe you missed this part. So Tege was asking, would you comment on the use of guarantees instead of cash for stay applications?
Yes.
And then there is a question of what actions are permitted or not permitted during the period when proceedings are being typed for purposes of lodging an appeal. Additionally, if a memorandum of appeal is filed within this period, can it later be deemed to have been filed out of time?
Just repeat that, please. Just repeat that question.
What actions are permitted or not permitted during the period when proceedings are being typed for purposes of lodging an appeal? Additionally, if a memorandum of appeal is filed within this period, can it later be deemed to have been filed out of time? Then what happens when a party has exceeded the pages directed when preparing submission?
All right. Thank you. Thank you. In terms, I think, of offering the form of guarantees as opposed to cash. Mostly, I think we leave this to the parties themselves to agree on this. It is not anything that I have seen the court imposing. It is left to the parties to agree on the mode that is most convenient. So I think that is what I would say. I have not seen our court prescribe this. In terms of what actions are permitted, I think as long as you have filed your notice of appeal in time and served it in time, you have applied for a copy of proceedings within time, and you have copied to the other side, I think your position is preserved, so that until those proceedings are ready and you have been able to then prepare the record of appeal, then I think time is at standstill for that length of time. So I'm not quite sure I understand the question, what action is permitted within that period, but that would be my response to that. In terms of exceeding pages, we bear in mind that judges are working under a lot of pressure. In fact, the work of the judge begins after you have ended your submissions. And the volume of work, I think you must also assist the court, because what you are able to articulate in 10 pages, I don't think adding an additional 2 or 3 will help your case that much more. So I think we generally take a dim view of the excess pages. But if it is absolutely necessary, ask the court to allow you to do so. And I think if you justify it, it is permissible.
Okay, Judge, I think we still have more time in the 5 minutes, or are we done?
All right. Okay.
James asked, would an appeal on an advocate bill taxation dispute be one of the matters that can be referred to mediation? And Samson asks, is filing a notice of appeal a prerequisite where the rules of the High Court direct that an advocate file a formal application seeking leave to appeal to the Court of Appeal? And I think our final question, allow me, members, and Kimani Horeria, advocate, says, thank you, Judge, for the eluded presentation. One comment on a problem we encounter regularly once parties consent to stay pending an appeal. There is very little mechanism to fast track the appeal being filed, and even when filed, having the appellant file its submissions, time being computed of essence. A respondent therefore will experience great difficulty in these circumstances.
All right. To James, the answer is yes. That if you ask me, is a matter that can be referred to mediation, and it can easily be resolved in terms of what is reasonable costs for the advocate. The question by Mr. Kimani, that once the consent is done, there is no control over how quickly then the appeal is heard. Now, if you look at the cause lists in recent times, you will notice that perhaps before one bench, the first 2 appeals are maybe 2019 or 2020, and then the third one will probably be a certified urgent appeal that is then fast-tracked. But as I said, even when we certify matters as urgent, we are still not able to deal with them in real time or with the urgency that deserves. And I think that is a practical problem that we have, given the number of judges that we are and the resources that we have. So I am not seeing in the foreseeable future us being real time, being able to deal with applications, being able to deal with appeals with the urgency that is deserved. but you never know. Maybe we'll have artificial intelligence assisting us in other ways. But I hope that we get there. So speaking of artificial intelligence, the presentation and Ms. Gashara, I'll probably share these notes with you so that you can perhaps circulate them at some point. So I uploaded that presentation to, I think you're all familiar with Google Notebook LM. So I uploaded my notes there and asked it to give me an analogy or a summary. And this is what it said. Practicing law at the Court of Appeal is a much like navigating an airport security system. Jurisdiction is the mandatory boarding pass. If you don't possess it, you cannot pass the entrance, regardless of how important your appeal merits might be. Timelines and procedures are the strict cues and deadlines. Failing to follow the exact sequence for lodging notices or requesting proceedings means you miss the flight and must file a separate, often costly application to get back into the system. That is what the Google Note LM said about what we have said today. So thank you very much, Ms. Gashara, for moderating this. Thank you very much, Council, for lending me your ear. I'm very, very privileged to have this opportunity. So thank you so very much indeed.
Thank you very much, my Lord.
Yes, Judge, maybe do you have any final words on today's topic?
I was tempted to read something here from Judge Kiage's ruling, and I hope nobody will be offended. You can look for this ruling in National Land Commission versus Johnson or Okiro. I am quoting this, but I don't share the same view myself. This is what the judge had said in this ruling. The application before me, dated that, is yet another poignant and disturbing reminder that the craft of litigation in this country, and specifically appellate litigation, is fast sinking towards the nadir and calls for urgent and concerted efforts to arrest and slide towards a point of no return beyond retrieval. I can only hope that judges, law schools, and senior practitioners see the lapses such as revealed in the motion before me as a symptomatic of a broken window that unchecked can only be a harbinger of worse to come. End of quote. So there is a cry there in that ruling. As I say, I do not necessarily share the same views. I think generally I have been impressed by the level of practice in the Court of Appeal. We all certainly have room to improve, and we continually learn from each other. And as I said, thank you so very much for this privilege to speak to you. So thank you. Thank you very much for...
Yes.
Yeah.
Yes, Judge, before you panel and the members, I want to recognize the presence of one of the council members, Wycliffe Oyo, who is also a secretary in the branch. I will just give him a minute so that he can speak and say something. Oyo, please proceed.
Thank you, Mudhoni. Good afternoon, everyone. My name is Wycliffe Oyo, council member at the branch and the secretary to the branch. I just want to say a big thank you to the judge for his wonderful presentation. I had the privilege of being with him, I think, just a month ago at a very high level training, and he remains as good as ever. From the branch side and from my chair, Mr. Kivuva, we are especially thankful to the Court of Appeal. This is the second time in just a week where we are having the second Court of Appeal judge. The judge you've just quoted, Your Lordship, Justice Kiage, was with us last week for a physical mentorship session at the Swiss Lenana Mount in a very equally informative session. And we want to just say that the practice at the Court of Appeal, as you've seen today, is very important for our members. not just because of the bread and butter side of it, but because still under our constitutional architecture, the Court of Appeal remains the last court of resort in a number of matters. And therefore, we must really get it right at the Court of Appeal more than any other court, if that could be correct, Judge. So personally, I may have the advantage of having practiced before this court on numerous occasions, but it's always a learning opportunity for all of us. And Judge, thank you for agreeing to this call. As Nairobi branch, we don't take it for granted, but we also think we continue participating in the bar benches, in the CUCs, and in all the platforms where we can move away from the comments that Judge Kiage has about the nature and state of practice in this court. I thank you all members, and may we all have a good afternoon. I'm most obliged, Judge. Thank you, Mudhoni.
Thank you very much.
Thank you, Oyo. I'm just reminded that members, the Rules Committee is currently reviewing the Court of Appeal rules, and members, you're asked to kindly submit your views. I take this opportunity to thank you very much, Judge. This was a very good session, very interacting, and very it was a learning experience. Thank you very much. We are hoping to host you again in the new town. Members, as always, this could not be possible without you. Thank you for availing yourselves. I know you're busy, but you've created time in your schedule for all of us to learn. Asanteni sana to my seniors. Asanteni. I also want to thank our chair for always coordinating for us to have these sessions with the judges. It's not an easy task, but we appreciate that in absentia, and the Secretariat for always assisting. Thank you very much, everyone. We can now log off and see you again next week. We are having another session with another judge for High Court. Thank you very much. Mbarikiwe.